Halo. After the matter was remanded back to the foreigner tribe, Part died. Sankodev Nagar by the order dated 17/07/2023, passed WPC number 246. The said tribe, after considering the evidence adduced by the petitioner of the proceed and hearing the party by order dated 21/12/2023, passed in FT within bracket D case number 157 of 2016 and FT case number 186 of 2016. D2 to number 8. Found the petitioner to be a foreigner under the Foreigner Act 1946, but legally accredited here. In the Assam of the specific honor of 25 the specific without having valid documents. Call for the records of the from the foreign tribunal. Please discuss.
I may be allowed to remain on bail, Lordship.
Let the records come.
No, Lordship, I was all along on bail, and High Court specifically directed to verify the voter list. But if I passed another order, that is not sustainable.
That's why let it
In the meantime, I may be allowed to remain. I was all along.
let the record.
Lordship.
May I please? My lord, in this case, altogether 22 numbers of document I have exhibited. And Lordship will find most of the document I have annexed with this petition also. First, your Lordship will find my family tree, my father's name is, that is just before page 1, without page marking. Family tree. And advertisement. Petitioner is Hussein Ahmed. His grandfather Gulam Jinari, grandmother Hashori Bibi, father Abdur Rahman, mother Kala Bibi. Your Lordship kindly turn to page 21. This is my lord 66 voter list. The last name is my father's name. Village Poop Jamuna. I got it, man. The next one is also page 23. Poop Jamuna. Here the issue is, my lord. This is the issue, my lord. Page 25, 97 voter list.
Yes.
Dikarumu. I have got it. Page 25. This is 97 voter list. So this is, my case is that I have born and brought up at village Pub Jamunagaon. Sometime in the year, मैं सब
Just a minute, just a minute. Ms. Verma,
Please stop it.
the tribunals, while passing such orders, have also expressed the role of the AGP, what they are doing. So how the tribunals was positioned to observe, it's up to you. You are representing the public. Heard Mr. Ayaruddin, Council Inquiring for Detention. In both the matters, we have seen the role of the SGP. For all, you have appointed them to the role. In both the orders, you will see. You have to read the order. Dissatisfied with the opinion dated 27/12/2023 passed by Lord Partner Tribunal Court Bozai from Nagar in FT within bracket T case number 1552 of 2015, whereby he has been declared to be a foreigner under the Foreigners Act 1946, who had illegally entered into territory of India within bracket Assam on or after 25/03/1971 from the specified territory without having valid documents. The petitioner has filed a certificate. All for the record of place this matter for motion immediately on basis of report from the consent.
I'm obliged. Will the interim
Observation 1.
This is this report and this in this one. আমি খালি গভর্নমেন্টৰ আছে না তেওঁলোকে ৰেকৰ্ড কিবা ৰেজিষ্ট্ৰি পৰা কল কৰিছে প্ৰডাক্ট বিষয় ঠিক না অলটা আনিব দিছে Yeah.
Magtina copy na one. Baki that's it. Okay. Where is Mr. Nath? You are appearing or Mr. Dinath will appear? Nath, we earlier assisted Mr. Nath.
Will come in. No? अरे बेटे আমার কিন্তু মাইনার যেগুলি অবশ্যই কোনটো আমার কোনটো পরে মাইনর
Partial division.
গভর্নমেন্ট সার্কুলার মাইনর গভর্নমেন্ট সার্কুলার তো থাকাই ভালো তারপরে বুঝবে তো সার্কুলার না বিআরপি এরপর থেকে পায় दिया नहीं तो तुझे दी
ना ठीक है मेडिकल मेरी मेडिकल रिपोर्ट दिखाओ मेडिकल रिपोर्ट का कॉपी है इंडिकेशन আসে নাকি না ইদার ইদার আসলে না না ভিডিও না ঠিক আছে ইন্ডিকেশন ফিল্টার না ওএম তো আছে না
Fill order. Correctly, it would be very quick. Mr. Nath reveals the record that is available for the court, which are two things. That the boy was picked up on 25th February 2016.
Yes, sir.
There is a community health center checkup and no such physical injury. The boy just complained about neck pain and backache, and for that there was no such physically injury found on his person. Well, the boy did not complain about any internal injury, excepting the neck pain and backache. So medicine was given. It was on the particular community health center on 25th of February. The original bed ticket and everything reveals that the boy was brought to this hospital on 5th of March, not on 3rd March, as it was earlier recorded, but it reveals the bed ticket itself. It is on 5th of March, the boy was discharged on 7th. And when the boy was brought on 5th of March, there were some aberration in the soft tissue, but no such other such previous injuries or any other injury. The mother of the victim at that point of claimed that he was badly beaten or physically tortured. But both the report medical report of 25th of February and the 5th of March doesn't reveal anything as such, as he claimed. Thereafter, when the boy was examined, pursuant to the order of the court, it was found that the victim, the alleged victim, is suffering from mild MR. Mild MR is mental retardation. Because he always having a tendency of feel like sleeping. He wants to sleep. That is his complaint. Maybe because of medicine he feels like sleeping. But he was found to have it. That was the last. Tell us in this circumstance.
My lord, as per the honorable court order, my lord, finally, peruse the order dated 10/5/2023 and 12/5/2023. It is a fact that 18.5 hours kept
No,
in the
because
police
at the time of
custody.
incident, allegedly the victim was 16 years.
Yes, my lord.
On that, there was a double murder case. The boy was found roaming around with the other accused. That's why the boy was picked up to know about what is the accused.
Yes.
Because that particular
But,
accused was involved in the double murder case.
But,
The old lady of 60 years and a child of 6
Yes.
So, while this boy brought into the station by concerned IO, in the meanwhile, in the same night, the other person,
yes.
But-
But my lord, police did not follow the procedure, my lord. Section 10 and 12, my lord. 12 and 13, my lord. Juvenile Justice Care and Protection Act, my lord. Did not follow. And 18.5 hours, my lord, kept in the police custody, my lord.
that's,
It is recorded, my lord, order.
whatever, I think there is some action taken that particular police officer.
Definitely, my
We
lord.
have initiated some action taken. See, two, three things are there. Pursuant to the judgment of the Honorable Apex Court, Police Accountability Commission has been constituted. All these states. If you have anything against the police personnel, then if you know him personally or they are no doubt you can always come for the court at the also at the same time it is a requirement to read the original judgment, the Apex Court regarding the constitution of police accountability. And you will see in most of the cases, our honorable judges are the chairperson of the act.
Yes.
Various orders have been passed. Presently, probably our justice to be private justice. So here we have seen the petitioner having approved, but definitely the right is there and the has it been proved by these measures that the victim sustained such injury while he was afflicted? There was nobody's case is before the court is that the victim was kept in the lockup. The incident has been protected here. That no doubt the boy was picked up and was also inquired. And he was asked to sit in a bench, not in the lockup. Yes, for the record which have that made. In the meantime, the police during the midnight came to know about the other accused of that double murder. All of them went to pick up that. And he was taken into custody, the other accused, he was brought into the police station. And thereafter, the morning, because as you know, after taking a such a double murder case, maybe in that particular place, it's very practical at that possible. There might be some delay. But it was not whether it was intentional delay or it was an inordinate delay, that you have to say from the record.
No, that is not
The
stated
record
by the
doesn't
IO
say- it
itself.
is a fact that the boy was handed over to his parents on 26th of April. That also during the daytime.
That delay was not explained by the private respondent also.
See here, it is
Before
a
this
fact.
honorable court matter.
No doubt the boy was picked up on 25th. He was medically examined. He only complained because everything is on record. That's what we are asking. He was handed over to his parents on 26th. Later, on 5th of March, he was brought to the hospital. Then they found during that, on 5th of March, some bruises and abrasions, soft tissue. Nothing else. Probably you should go through the records and then satisfy yourself. Can you better to make it happen? Have you gone through the record? Have you gone through the record?
I have not got.
You have not gone. Do one thing in presence of government advocate, you go to the record. Go through. After you are a court officer, then point it out. What of the things are there. But as far as we have gone to the record,
Yes, ma'am.
we found those things there.
This discuss, my lord, the petitioner.
Definitely, if
Yes.
there is any violation.
Yes.
We'll
Record
definitely.
record to check করবা এটা
To do
on the basis of record submission
And
to
we cannot
submission
go
to
beyond the record, right?
true that's
Go to the record and
That's-
verify and tell us. So now, we may be allowed to examine
Yes,
the records in
Lordship.
presence of
yes
person to our order. That is 1803.
তাহলে হবে।
The records of Vidyapur PHC as well as Bongaigaon Civil Hospital. That will be registry. Has been placed before the court. We have perused the same. For proper adjudication of the case. Mr. K. Kolita, right?
Yes, ma'am.
Learned counsel for the petitioner is allowed to peruse the relevant records, those records in original placed with the court in presence of government advocate. Placed on 3rd of April. Go to the records to make a note whatever. But you will see the hospital tickets and everything. of, The first medical report is of 25th.
Yes.
The doctor was examined. The Vidyapur stage. Then next was at Bongaigaon Civil Hospital. The bed ticket is of 5th of
March
and he was discharged on 7th. You can note it down, you go through. Tell us. See, necessarily you can understand. And then mother
Yes, ma'am.
child was 16 years old. Was kept in the yes. It's already. That case will be always
Yeah.
having anxiety. And possible.
Correct.
The thing is this, we have to go, you say,
True, my lord. Got you. Problem, my lord.
Note it down, Mr. Police.
Yes, ma'am.
43.
Hi.
Yes,
No.
we wanted to know. We wanted to know whether the ERO has any message.
Yes, yes.
Inform. Mr. Sharma, what are you placing? We wanted to know whether the ERO has submitted any such report
Mm,
against the petitioner.
No, Lordship.
There is no report.
No report, Lordship.
We can
They could
record
not
that.
find. Lordship, they are searching, Lordship, whether,
See, it will be the ERO will be aware.
yes, Lordship.
The thing is whether first
But-
of all, the report came, no voter reference has been made. We wanted to know from you
Yes, Lordship,
whether the ERO has furnished, whether the Superintendent of Police Board received any such report from the ERO or not.
not received.
That is has to be there. It will be in the file. It will be in the record.
They could not find, Lordship, and yesterday they telephonically asked to election office, Lordship, and concerned officials are busy in some election duty, Lordship. That's why, Lordship.
Heard Mr. A. Ali, counsel for the petitioner, and Mr. G. Sharma, training counsel from Department Assam for the respondent numbers 2 and 6. Also heard Mr. T. Pegu, learned counsel on behalf of Mr. A. Ali, standing counsel election commissioner of India for the respondent number 3, and Mr. P. Sharma, additional senior government advocate Assam for the respondent number 5. Petition number 1 is the wife of late Afsar Ali, alias Afas Ali SK. Now, petition number 1 claimed to be the wife of late Afsar Ali, alias Afas Ali SK of village Piringabari under King Police Station of District Nagaon. Where the petitioner numbers 2 and 3 are sons of her and her late husband, Afsar Ali alias Abbas Ali Sheikh. Petitioners contended that in the voter list of 2018 relating to Hing Legislative Assembly constituency. Their name has been marked in column T as doubtful. Hence, they prefer this repetition for removal of said D mark colon from the voter list of 2018. D mark from their name for the voter list. Notice in this case was issued on 30/05/2018. And the respondents in the election commissioner will be or its authorities were directed to apprise the court about the steps taken by it after marking the petitioners as doubtful in bucket T voters. However, the respondents did not file any affidavits in the matter. On being inquired, Mr. Z. Sharma, Standing Counsel, Home Department, on clear instruction from the Superintendent of Police, Border, Nagaland, apprised the court that as on date, no such case has been initiated against the petitioners considering them to be doubtful in bucket T voters. Mr. Sharma, Standing Counsel, Home Department, paragraph. On further inquiry, comma, on instruction submitted that the Superintendent of Police, Border, Nagaland did not receive any such report from the Electoral Registration Officer of Nagaland District. Marking the petitioners as the voters and for referring their cases to the concerned foreigners tribunal. Mr. Ali, learned counsel appearing for the petitioners, also could not place before the court as to whether in the subsequent voter list published after 2018 relating to Hing Legislative Assembly constituency, whether the names of the petitioners have been shown as doubtful in bucket T voters or not. considering this petition. Devoid of any merit. Hence dismissed. However, it is made clear that if the petitioner been shown as doubtful in the voter against their name in the voter list, published recently for the 2024 parliamentary election on 13th means they may approach the appropriate forum for redressal of their grievances. The written instructions placed by Mr. G. Sunny Council that we received from instrument of the voter now come. They came to the department.
May I please solution? My senior is at only another road. I am 2 time being. Item 35. Time being.
Mr. Sharma. Don't know whether this particular application
Item
is still having any force or not. An order was passed when this writ petition was moved.
Yes, Lord.
And that order, interim order, was of 9th of August 2017. The relevant records was called for. The writ petition is against an order of the Furnace Tribunal Jorhat,
Yes.
dated 6/5/2017, wherein the petitioner was declared to be a foreigner, illegally entered into territory of India on or after 24 March 2010. While this notice was issued, the
Lord.
petitioner was directed to appear before the Superintendent of Police Court at Jorhat.
Yeah.
Because it was passed by tribunal. The petitioner later filed its interlocutory application on 13th of November 2017. But there was a defect on it.
Yes.
The defect was cured. Defect means paragraphs were not inserted in the
Yeah.
affidavit. So defects were cured on 5th of when? 3rd of February 2020.
Yes.
Now, thereafter renumbered as IA 294/23.
Hmm.
We do not know whether the prosecutor has been taken into custody.
Yes, doctor.
Yes, the record reveals the reference was made by the Chief Sagar.
Yes.
Superintendent of Police Board. But there is no tribunal at Chief Sagar.
Yes.
Foreigners tribunal is available only at Jorhat,
Yes, doctor.
right?
Jorhat, Shipsagar and Soraido falls under Jorhat.
Even for Soraido, there is no tribunal.
Yes, doctor, we fall under Jorhat
All
tribunal.
Jorhat only.
Yes.
Separately for Soraido, separately for Chief Sagar, tried by Jorhat.
Yes.
So that's whether this proceeding has been taken into custody. Matter is pending since 2017, November 2017. For 3 years, they have not corrected the defect.
Yes, doctor.
Ultimately, in February 2nd, 3rd, 2020, they have cured the defect.
Hmm.
Right. As of now, we don't.
I will take the instruction. Doctor.
And so
Whether
your
the
shift,
petitioner is in custody or is still out.
my lord, out, my lord, actually the Shipsagar, my lord, SP Shipsagar was
He
not,
is still outside the custody.
Yes, Lord.
He has not been taken into custody.
no, lord.
Siddha Fund.
Now, because of this application, lordship pending,
To the conduct.
Lord.
my lord, I approached you, lordship. The IA is pending, lordship, that is why
You
he,
first,
he went to the, my lord,
you first let us know on Tuesday. Wednesday,
When,
not possible Wednesday, Thursday.
Lord.
Whether the Superintendent of Police Border, Chief Sagar, has taken him in custody.
Yes.
Pursuant to the order of the tribunal. If he is outside, but
my lord, what I am submitting, lordship. My lord, initially, my lord, he went to the, my lord, office of the SP, my lord, Jorhat. My
let
lord,
us
to
know whether he has
appear.
been taken into custody, whether he is outside or if he is outside, don't take him into custody now. Also
Lord.
inform him. If he is outside, let him remain outside.
Lordship.
Lordship.
Don't take him into custody.
My lord, otherwise, my lord, there is every possibility, lordship.
Just
will
get
take-
the information and you want to know the order of the tribunal,
Yes, Lord.
you just note down.
As per instruction, my lord, he is outside, lordship, working. Anyway, my lord, I may be given chance, lordship, I will appear, lordship. By this,
SVR, you note down. SVR. Reference is SVR/B/2011.
Lordship.
/1888. The date 28th of October 2011. Superintendent of Police Border, Shipsagar. The case number is FT/SVR
Yes, Lordship.
536/11. This is before the tribunal.
56 oblique.
FT/SVR /536/11. The opinion is of 6th of May 2017. Name of the proceeding is Muhammad Matibur Islam, son of Jabbar Islam. Village is Sangmai Gaon
Yes.
under Gorisagar Police Station. But there is a but. He is a permanent resident of Ghoramukh,
Goramukh.
Ghora, DHORA, Ghorahap, Ghoramukh. Police Station, Kanpur District, Nagaon. Let us know on 28th.
Yes, sir.
We'll pass the order on 28th. List this matter again on 28th. enabling Mr. Deep Sharma, the relevant instruction.
I Yes. Yes.
Iron number 906.
Why is it listed today?
Listed today, there is a miscase or 906, your lordship kindly take up.
Oh,
906 being included because the secretary,
because the matter has been fixed today, but
please,
the regular bench is not available.
no, please, regarding implead, my lord, your lordship. Substitution, my lord.
Shall we? This is a special bench, only
actually-
because that division bench is not available.
My lord.
Port number 1 is not available. That is the reason it has.
No, that is not the, actually, the impugn order was passed by,
By whom?
Honorable Justice.
Yeah.
Mehdi.
No, presently, port number 1 is not available.
I
Because the bench because these matters have to come before DB1
My lord.
and it of course listed before DB1. Presently, DB1 is not available
My lord.
today. Matter was fixed today by order of 15th March.
Yes, my lord. That 15 March order is my lord only for the, that today, actually, that was that
substitution.
only on the substitution.
We'll fix it on 1st April or 2nd April. That
Third
will
or
be better.
fourth, my. Third or fourth.
So third,
Lordship.
on the priority council to depart the case from third. We'll go with today.
Lordship, pass over for time being. You can have a copy of the IS. Anna. Copy.
Yes, ma'am. Ms. Verma, what you have to say?
Order was passed in 22, Lordship.
Order was passed in December 2022.
15 days time granted.
We obtained a certified copy in February 2023 and filed this application in March 24. What do you have to say?
The council, I do not want to make any comment on the council, Lordship. The
This is not
conduct
the
is,
part of the council. These are the litigants.
Until now, I'm quite sure the petitioner is outside, not taken into custody also. Lordship may extend the time, but with a cost, Lordship, because this conduct will otherwise keep on continuing 22 order to 24, Lordship.
चलिए रखते हैं। What's your good name?
And they can.
You are appearing on whose behalf?
See, Bora.
Or a counsel for the applicants.
What to ask?
Then during the delay in filing. We direct petition. Okay. District Legal Services Authority, Nagaon. The applicant petitioners have now appear before the furnace participant of Nagaon before 5th. Placing the certified copy along with a copy of the receipt regarding deposit of said cost of respect of the district legal services. In order. Thereof. That's why the direct assessment. I think the cost of WBC. Notice in this case was issued on 19/20. And records of FT case number 76 of 2016. Was called for of the learned furnace special setting knockout. Office note dated 16/03/2024 reflects that the records of the page record the relevant record from the said furnace cabinet be received. A copy of this order also be served this Farmers Cafe Council Department. Order of hard copy. For the cabinet. Second, of all, super double. List of 20 people. On the same day, the petitioners will apply to protest that she appeared. before. Person to democracy.
Lordship, IA has been closed. God bless Lord.
Lordship, this IA lordship has been filed, lordship. That lordship, due to some reason, lordship, he could not require due in time, lordship, before the SP lordship. That's all, lordship, just, I'm humbly prayed, lordship. Further, some time may be granted, lordship, so that he can appear, lordship. If he's a labor lordship, he went to outside lordship, in the Kerala lordship. If he also having a mobile phone lordship, that's why it could be communicated to him, lordship. That's why he failed. So the date was in paragraph 11, lordship.
Miss Verma, do you have the 1964 order with you?
Yes, sir. Yes, Lordship.
Read sub order 6 of order 3.
Where the proceeding appears, Lordship, that one. Where the proceeding appears or is brought before the Furnace Tribunal and he produces the documents in support of his claim. The Furnace Tribunal may release such person on bail and decide the matter accordingly.
So basically, when he appears, the bail has to be granted,
Yes.
right? In most of the cases from the records that we found that in some cases the petitioner, the proceeding appears, did not appear physically, but through his or her counsel
Counsel.
remains absent. Read the next clause.
7. In case where notice is duly served, the proceeding shall appear before the Furnace Tribunal in person or by a counsel engaged by him or her, as the case may be, on every hearing before the Furnace Tribunal. The Furnace Tribunal shall give the proceeding 10 days' time to give reply to the show cause notice and further 10 days' time to produce evidence in support of his or her case. The Furnace Tribunal may refuse a prayer for examination of witnesses on commission for production of documents
That's a
if
different issue. So it is the proceeding is DP1 to appear before the tribunal on every date fixed
yes, Lord,
by in person or through his or
counsel.
her counsel. Here is a case. The proceeding after filing this petition or before filing this petition, someone or during the pendency of the proceeding left for Kerala. Is it possible?
He cannot, Lordship, but this is what is happening.
How come? If it is happening, what steps you have taken?
And the plea, I do not know the steps, but the state is taking up, Lordship, but most of the times,
You are the Home Department,
yes, Lordship.
so you are supposed to answer.
Lordship, so far I understand,
They,
Will come back.
Lordship.
some time, some dates are given for them to appear as per convenience, Lordship. But taking advantage, sometimes they do not appear at all. We have to take steps in this regard.
Okay, without it. Not you know, 20%. No, people- Tell us what to do. You tell him. And we'll do according.
I'll give it a bit of time. Kolkata Puri.
Lordship, in this matter, where the procedure is seeking extension,
Tell us. If it is taking time to appear. The petitioner was aware of the order of the tribunal passed on 4th of August 2023, wherein he was declared to be a foreigner. And thereafter, the petitioner filed this writ petition. He had shown this affidavit in December, while he was in party or while he was in Virginia. But as per this application, after filing of this writ petition, he left for Kerala.
yes, Lord.
So everybody can sleep away.
Lordship, some things are not um, believable, like he has no mobile phone. In today's age,
Maybe possible. Let us assume he is too poor to buy a mobile. He may not have any.
Lordship,
2000
password is
to
so
buy-
poor, Lordship, so
Possible.
agreed, Lordship.
No, there are people without mobile.
Twenty-two order, Lordship.
But
passed
thing is this, that is the
20
reason we're asking you. He is aware of the fact,
that there is a proceeding against him.
he has been declared as a foreigner.
Yes, Lordship.
That is why he filed this writ petition.
And whether he came to file it or not, that is a question mark now.
That is a different issue altogether. Again,
Yes,
we are not
Lordship.
here. So he left without obtaining any order from the court.
How could he leave?
So what are the procedure? What are the, because the tribunal is only supposed to give its opinion,
Yes,
right? Once the opinion is given, it will be the concerned superintendent of police order. He should do something,
yes, Lordship.
and the SP border comes under your jurisdiction. Then a person declared as a foreigner in August 2023, how can he moved out of the state? Tell us how he can move out of the state. That means there is no action from the,
There's no coordination, no action, no coordination, Lordship. This is the fact.
who will be responsible? Home Commissioner,
There's a complete,
Home Commissioner. Do you think he should be here?
no, he shouldn't be here, but Lordship, some direction, some stricture has to come from the court
No,
to give them a
definitely we'll
reminder,
pass
Lordship.
direction only when we'll come to know what kind of actions you take after a person is declared to be a foreigner.
In half of the cases I see, even if they have obtained order for interim, they do not go and take the bail, Lordship. Lordship has also asked us to get so many instructions over the last 3-4 months. Just now I received one instruction saying that the lady never appeared and she's absconding, avoiding bail also.
Point it out to us, we'll cancel it. If not appear during the time, reject it, that's all.
It is, Lordship, because there is no coordination, there is no data as such to coordinate the cases with the police stations and the foreigners tribunal. This coordination is just not happening, Lordship.
No problem.
Lordship may have a
A
word with
reference
the
being made by
SP.
the Superintendent of Police Border,
This is Kamrup, I think, Lordship. SP border Kamrup. Whether they are receiving these orders or not, that also is has to be ascertained. The opinion is passed, they say that a copy may be forwarded to the SP office. Whether it is reaching them on time or not, some mechanism has to come in place, Lordship. It's already too late and too long now.
Kamrup, Guwahati. White memo number AP, in bracket capital B, FA/73/07, dated 850/07. Reference under Foreign Act 1946. As to further, the applicant slash proceedee is or is not a foreigner. The Foreigners Tribunal number second, Kamrup at Boko, in B.F.E. case number 70/16. After hearing the petitioner, the other party, and considering the evidences deduced by him, by order it is 04/08/2023, opined him to be a foreigner under the Foreigners Act 1946, but illegally entered the territory of India, Assam, on or after 25/03/2021. The petitioner obtained certified copy of the said order dated 05/08/2023. Their opinion, or the order dated 04/08/2023 above
Itu copy mo lang.
07/09/2023. And filed this writ petition on 11/12/2023. Not this, 11. The application I had connected. them. The court on 18/12/2023, while issuing notice to the respondents, with application number 7293, filed and corrected. While issuing notice to the respondents in the interim, granted bail to the petitioner with specific directions. Further, directing him to appear before the Superintendent of Police Border Kamrup at Amingaon on or before 04/01/2023. The applicant slash petitioner stated that after filing of his said writ petition WPC number 7294/2023, he left for Kerala to earn his livelihood. And returned sometimes in the first week of March, first or second week of. And he was not aware of the order of the court dated 18/12/2023, passed in his said WPC number. Hence this application by the applicant slash petitioner for extending time, enabling him to appear before the Superintendent of Police Border Kamrup and to comply with the order dated 18/12/2023. Passed it. WPC number 7294. To appeal pay accordingly. On being inquired, no fruitful reply could be given by the Standing Council Home Department about the procedures, about the steps taken by the Home Department of the state with regard to the procedures who are declared as foreigners. Okay. Whether they are taken into custody, forthwith, or allows them to roam around freely within the country at various places, even after declaring the proceeding to be a foreigner by a tribunal on a reference being made by the Superintendent of Police Border of the concerned district. Placed on 2nd April. On the said date, the Commissioner Secretary Home Department shall apprise the court by filing an affidavit about the steps taken by it regarding the proceedings were declared to be foreigner by the Foreigners Tribunal about the action taken by the step action and the step taken by after proceedings declared to be a foreigner by Foreigners Tribunal on such reference made by the Supreme Court. Let's step up. Yes, next.
Pleasure.
Copy of this order be furnished to the registered judicial shall communicate this order to the Commissioner Secretary Home Portfolio.
Lordship, a little longer date because, yeah, holy.
So you want the proceeding to
No,
roam around in the
no,
country for
no,
further
Just, Lordship, on the
sufficient?
third or fourth.
Sufficient.
Made please.
See, first of all, you should try to understand the Sarvananda Sonowal 1. Why the apex court said it's an war? Why? That is why yesterday we said you are not even aware. A PIL has been pending before the Honorable Apex Court with regard to the illegal migrants. The steps, how they is to manage everything. The PAN card, the Aadhaar card, the voter list. Everything was given in details. That's why the PIL was entertained by the Honorable Apex Court. Normally PIL will not be entertained by the Apex Court like this. All details. And it's happening, not only in, I'm talking about the state of Assam.
Everywhere.
Yes.
But what has happened in this case, my lord? The referral authority in the inquiry, my lord, it has opined that the suspected is Indian by birth. And thereafter, the impugn opinion has been passed, whereby declared the petitioner to be a foreigner, my lord.
What is your grievance?
My lord, my grievance is that the impugn opinion passed by the learned tribunal, my lord, is contrary to the reference, my lord. Since the reference is that the petitioner is an Indian by birth.
Is that the reference?
Yes.
Let
My
us
lord,
see.
the reference is at page 39.
If the proceeding is to be an Indian by birth, why the reference was made?
That's why, my lord.
Why the reference was made?
My lord, that's why the reference is very clear, and the higher authority has also accepted the same inquiry report, my lord. In that case, my lord, reference may not be made, my lord.
Did
And
you
if the
receive-
FT,
Did you receive notice?
my lord,
Did you receive notice?
yes, my lord, notice has been received.
Did you appear?
No, my lord. In that case, my lord, I have already stated
That
what
you
had
need
happened.
not-
The petitioner,
Once a reference is made and the tribunal issues notice and the proceeding receives the notice, did not appear in the tribunal.
yes,
What
my
kind
lord.
of protection you need?
But my lord, I have already
Same
categorically
thing,
stated, my lord,
instead of coming here, that means what? The proceeding must be a very wealthy person. Instead of going to the tribunal,
my lord, what had
in his place, he likes to prefer a writ petition before this court. Good.
My lord,
See,
my lord, what had happened, my lord, at paragraph 9, I have categorically stated what had happened. The proceeding has come, but when he discussed the matter with the engaged advocate, my lord, and the advocate, after going through the record, my lord, he suggested him that not to appear because the reference is in positive manner. That
where from he came to know?
my lord, he go through the record, my lord. But I have my lord, stated in paragraph 9 of my writ petition, my lord. That's why, my lord, the proceeding could not appear on the next date, my lord. The impugn order has been passed. Just only next day.
How we have obtained that reference that was, where is the copy? You said page number?
Page number, my lord, 39.
39.
This certified copy, my lord.
When you have obtained,
मतलब date. Date not visible, मतलब here in the seal. Certificate to be true copy.
When you obtain the certificate. All the tribunals, when such application is filed for certified copy or for whatever, normally the system is in the district judiciary. First of all, they will cut the stamp, right? They will mark it, cross it,
Yes, sir.
and will give the date. Will
But
give the
well-
date. To find out, that is the procedure followed in all the district courts. Where is the date?
The ticket has cut, but the date.
This is the reason we are asking you.
I think in the round seal,
So was
मतलब
the
date was
original.
the
So was the original.
original not with me now, मतलब. But I will be.
In which paragraph you have stated that you applied for the certified copy?
मतलब the applied for certificate copy I have not stated here, मतलब. After paragraph 9, I have stated.
So without appearing before the tribunal, your counsel obtained the certified copy.
Yes, मतलब that certificate
Is it
copy has.
possible? Is it possible, Ms. Verma, Mr. Sharma? It's not possible because if a certified copy by a lawyer is possible only when he or she enters
Yes, sir.
on behalf of a particular
Yes, sir.
procedure.
After filing of the Okalat, my lord.
That means he has to file his color.
That certificate copy, I think,
How-
मतलब after
how
the
come?
after
It is
the
not an-
opinion, मतलब the
It is
certificate
not
copy has been
procedure
obtained.
who has obtained, you said on the advice of the lawyer. Show us the procedure that you have followed while obtaining this certificate.
After the simple order, मतलब I have.
We want to know from you, Mr. Counsel. What procedure followed while you have obtained this certificate?
मतलब in that case, मतलब some time may be given, मतलब I will take instruction, मतलब in this regard.
Anything else you like to submit?
My lord, otherwise, my lord, I have some judgment, my lord, out of the similar cases, my lord. This honorable court has passed order by saying that the tribunal ought to have been referred the matter, remanded back the matter to the referral authority and cannot pass such type of orders, my lord. The 2-3 judgment is there, my lord, out of the same fact. First of all, my lord, in case of Monwara Khatun, my lord, WBC number 2674/2016. Whereas in this case also, my lord, the referral authority referred the matter before the tribunal by saying that the petitioner is a bona fide Indian, and thereafter the tribunal has passed order by which declared the petitioner was foreigner, and then this honorable court has interfered into the matter. But the relevant portion is at page 6 of the state judgment. My lord.
Para 6,
My lord,
para 6.
no, my lord, page 6. The WBC number 2674. Monwara Khatun. 2674. After first paragraph, my lord. After hearing the matter, the tribunal passed the order dated 14/3/2016 declaring the petitioner had illegally entered into India without authority on or after 25/3/1971. Adverting to the affidavit shown by the Director General of Police Assam, it is stated that the petitioner was initially suspected to be a doubtful voter by the electoral registration officer of number 26 Bleshibara West Legislative Assembly constituency, who thereafter forwarded the case to the Superintendent of Police Border Dhubri, who in turn directed an inquiry through Sub Inspector of Police Border Sri Basant Das. Report of the inquiry officer and remark of the Superintendent of Police have already been noted. It is stated that as per the memo dated so and so issued by the Office of the Additional Director General of Police, Border Assam Bhavan, illegal migrants determination by Tribunal Act 1983 and the illegal migrant determination by Tribunal Rules 1984, wherein place there was no scope for further inquiry by the Office of the Superintendent of Police following order of the Electoral Registration Office. Since the order of the Electoral Registration Officer was a quasi-judicial, therefore, irrespective of whether the suspected person was found to be an Indian national or not, reference is to be made to the tribunal. As a matter of fact, Election Commission of India had also issued a notification dated so and so, stating that all rightful cases received from the Electoral Registration Officer were required to be referred to the Foreigners Tribunal, and no authority other than the Foreigners Tribunal could decide the case. It is in such circumstances that the reference came to be made notwithstanding the report of the inquiry officer. The affidavit has referred to full bench judgment decision of the State versus Muslim Mandal, so and so reported in so and so, wherein it has been stated that the reference made by the referral authority cannot be mechanical. The referral authority has to apply his mind to the materials collected by the investigating officer and thereafter to make the reference. In so far case of the petitioner's concern, it is stated that Superintendent of Police Dhubri, after proper application of mind on the report of the inquiry officer, came to the conclusion that petitioner did not appear to be a foreigner. In the light of the above position, we feel that the tribunal ought to have returned the reference back to the referral authority. Superintendent of Police Dhubri notice issued by the tribunal was apparently contrary to the reference made. Though this court has clarified that if tribunal finds a reference to be contrary to the materials on record or finds the reference to be faulty, it should remand the matter back to the referral authority for making a fresh reference. But in the instant case, we find from the affidavit of the Director General of Police Assam dated so and so that report of the inquiry officer as well as endorsement of the Superintendent of Police Dhubri were made after proper application of. In such circumstances, without entering into merits, we feel that impugn order passed by the tribunal dated so and so cannot be sustained and is accordingly settled. And then another judgment by law in 2022 1 GLT, page 790, my lord. Paragraph 5, start from paragraph 5, my lord. We have perused the original records, requisition in this regard, and also seen the inquiry report as contained in form number 1 in paragraph 21 of form number, which relates to the inquiry officer final finding. It has been recorded by the inquiry officer as follows. During inquiry, it appears to me that suspected Sushil Mandal, son of late so and so, is not an illegal migrant who could produce the sufficient valid document in support of his nationality. Hence, the case is forwarded through proper channel to the Honorable Foreigners Tribunal for opinion of the judgment. Then, my lord, is skip and the paragraph 7, the aforesaid provision, my lord, paragraph 6, in our view, a reference can be made to the tribunal for determining whether the proceedee is a foreigner or not, only when a doubt arises about the nationality of the person concerned, or when there is a specific finding by the inquiring authority that the proceedee is suspected to be a foreigner, contrary to the claim made by the proceedee that he is an Indian. Thus, when a question has arisen as to the nationality of the proceedee, obviously that requires to be resolved by a competent neutral forum which has been provided under the Foreigners Orders 1964 by creating the Foreigners Tribunal to determine the issue. It has been provided under Order 2 of the Foreigners Tribunal Order 1964 that the central government may make an order for constitution of Foreigners Tribunal for the purpose for its opinion as to whether a person is or is not a foreigner within the meaning of the foreigner. The aforesaid provision, however, does not mean that any reference can be made even if there is a finding that a person is an Indian. If a person claimed to be Indian and the inquiring authority after necessary inquiry has held that he is an Indian, it cannot be said that there is a dispute or any controversy as regards the nationality of such person, which requires the reference to the tribunal as the need for determination is not there. The Foreigners Tribunal, which has been created in terms of the 1964, is meant to give its opinion only when there is a dispute of doubt about the nationality of a person. The question of referring a matter to the Foreigners Tribunal does not arise when no such dispute or doubt exists. The purpose of constituting the tribunal is to decide the nationality of a person when there is a doubt or dispute about it. A valid reference can be made by the referral authority only on the basis of the certain findings which has been arrived at by an inquiring officer. In the present case, the inquiring officer has given a finding that the proceedee is not a foreigner. Under these circumstances, the referral authority could not have referred the matter to the Foreigners Tribunal for its opinion. If the referral authority does not agree with the finding of the inquiry officer, it must be based on the cognate, reliable materials and not based on the ipse dixit of the referral authority. There could not have been a reference to the Foreigners Tribunal to get an opinion when there is already a finding that the petitioner is an Indian and there is no dispute about the nationality, and as such, any such exercise by the tribunal based on such reference will be a futile exercise. The importance of the proper reference by the referral authority has been highlighted by full bench decision of this court in State of Assam versus the Muslim Mandal and others reported in 2013 1 GLT 809 by emphasizing that the reference by the referral authority cannot be mechanical and the referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making the reference. It was also emphasized that the referral authority, while making the reference, shall produce all the materials collected during the investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about the existence of the main ground before issuing the notice to the proceeding. Para 98 of the above decision, the Muslim Mandal is reproduced here and below. The reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order recording his satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collected during investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about the existence of the main grounds before the issuing the notice of the proceeding. From the above, it is clear that the referral authority must be satisfied that there are grounds for making such reference. It is right that the grounds for making the reference will arise only when there is a doubt about the nationality. As a corollary, when there is no doubt, there cannot be any ground for reference. In the present case, there is a finding rendered by the inquiring authority that the proceedee is not a foreigner, and no dispute or doubt has been also raised about the nationality of the petitioner. As such, the question of referring to the foreigner tribunal by the referral authority does not arise. Accordingly, for the reason discussed above, we are of the view that the impugned opinion dated so-and-so passed by the learned member, Foreigner Tribunal Kamrup so-and-so, is void ab initio, as it lacks jurisdiction to decide the matter, since no jurisdiction has been conferred upon the tribunal to give an opinion where there is no dispute about the citizenship of the proceeding. Accordingly, the impugned order dated so-and-so is set aside. Then, my lord, টু থাউজেন্ড 1 GLT
নাম কি?
একটু সুশীল মন্ডল।
1 GLT.
Relevant para,
Malad,
what is the relevant para?
in which one Malad?
Sushil Mandal.
Sushil Mandal Malad, relevant para is para 9 to
Same.
11.
What is the third one?
Malad, third one is the 2017 2 GLT.
Yes,
1065.
1065.
In that case, Malad, the para 5, 7, 8, and 10 is the relevant.
What is the proposition there?
In this case, Malad, proposition is that if the tribunal find the reference is faulty, without going through the records, the referral authority has referred the matter by saying that petitioner is Indian. If the tribunal finds that the reference is faulty, then he ought to have been remanded back the matter to the referral authority for fresh reference. This is the proposition in this case, madam. And
So counsel, just tell us one thing. Whether police can determine the citizen,
cannot be, madam.
sorry, you fully agree with that?
Yes.
If a police during inquiry finds that these are the documents the proceeding have placed and he has taken part in India. So according to me, he is Indian citizen. It is sufficient.
Not well. In that case, Malad, this 2017 2 GLT is clearly stated because there is a clear direction that the referral authority refer the matter along with the documents on which they have given their opinion, Malad. So if tribunal find that the documents which produced before the relevant tribunal and the opinion given by the police is
Is
contradictory,
not it like
in
this?
that case, Malad,
Is not
the-
it like this?
that may be remanded back.
Is not it like this that when police file search sheet, along with this search sheet, the statement of the person's acquainted with the incident made under 161, the medical certificate of the victim, the victim statement recorded under 164, and all other documents. And these statements are before the concerned magistrate. And the magistrate, going on perusal of the records, comes to the conclusion that there are certain materials to proceed with the case. Right? And then cognizance are given. The cognizance are issued, and then from the trial starts, then from the procedural given summons are issued. This is as per the CRPC. Here, in these matters on the Foreigners Act, police makes an investigation. First, the police makes a prima facie investigation, comes to a finding that the proceeding failed to give the documents. So the concerned investigating officer makes a report to the Superintendent Police Board that the proceeding suspects to be. Thereafter, the Superintendent Police Board issues a note, you investigate. Then there will be a proper investigation. There will be a number of the investigation case number, the concerned police station, and the concerned inspector who makes the investigation submit it. And in that report, let us assume a case where certain documents have been placed. This is the voter list of my father of 1965 or 1966. This is the voter list of 70. This is the voter list of 1989, right? And my name is in figure in the voter list of 1995. So I'm Indian. So police personnel found, yes, it is in the 1966. one Mr. A and Madam B was there. Even in 1970, one Mr. A and Madam B's name is there. In the 1989, A1 and B1 is there, not A and B. And the procedure is saying his name figured in the voter list of 1997, along with A1, B1. So, according to him, he is
Indian.
by birth
Indian.
Indian. But he writes that these are the documents on the basis. He comes to an assumption that the petitioner, the reciprocity is in Indians. But for proper finding, he said matters to be decided by the opinion should be given by the tribe. Verifying those materials, the Superintendent Police of Border refers the matter to the tribunal. The tribunal going through the material opens up the case, issues notice. He also comes to the prima facie satisfaction. Just like the cognizance taken in the criminal matters, here also he is being satisfied, he issues notice. Now, can there be a case where the police during the investigation, on the basis of this 66 or 65 voter list or 70 voter list, then the 89 voter list, then the 97 of his own, he comes to a conclusion, he appears to be,
Indian citizen.
but he writes that there is need to be an opinion. What do you indicate by that? According to the police officer who investigated the case, he feels that the prosecutor is Indian. But for proper opinion, because there is something, and he writes that it should be decided by the, its opinion should be given by the foreigner. That means what? Was or was not there is any doubt on the mind of the SI?
Definitely, my lord, your lordship is correct in that manner. my
Well,
lord.
if he is,
But-
because you see the inquiry, in the inquiry, he has produced certain documents. As you have said, the police officer is not the person authority to determine the citizenship. He feels that these documents is sufficient for a person or for a prosecutor to prove to be his Indian citizen. But in spite of that, he writes that it is better. So he had some doubt. That's why he writes it to the, or better for certain reason, it should be better that it should be given by the opinion. Because he had that doubt. Now, once that doubt has been given up, showing that he is the foreigner, he is just saying that that is the act, the Foreigners Act is very clear, is or is not. That can only be decided by the Foreigners Tribunal.
That's correct,
That
my
is-
lord. But
If it is the case of the prosody has been found during the inquiry by the concerned investigating officer that the petitioner, the prosody is an Indian citizen. Question of having that second thought of sending it for an opinion doesn't arise,
doesn't arise.
right?
Yes.
So that satisfaction is on the first satisfaction is on the basis of the investigating officer. Even when there are sufficient documents, let us say, whether the investigating officer can determine the citizenship, you said no. And rightly said no. Then where this assumption that a person is a foreigner or not?
My lord, but these honorable court in several
Tell us.
judgments, that issue has already been
That is
decided.
the
my lord.
reason when the
That
full
has,
bench-
issue has already been decided
when
and
the
clearly said.
To read the full bench judgment. You have asked straight para 98 in the
Yes.
other judgment. You read it again slowly for your own purpose. You read para 98 has been recorded in that particular.
Para 98, my lord. the reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order recording his satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collected during investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about the existence of the main grounds before issuing the notice to the prosecutor. But here,
Now, who is
what,
the referral authority?
but referral authority is the police.
Referral
Government,
authority-
central government ultimately through the policeman.
Referral authority is the Superintendent of Police Board,
Yes,
right? Who
Yes.
refers.
Yes.
It is, he should prima facie satisfy
yes,
that though this is the report, but it needs to be clarified.
Yes.
And for that purpose, it is as per 98, it is very clear. It is the duty of the referral authority.
Yes.
While considering the report,
yes,
and also says he did not write it in elaborately, but
his satisfaction is sufficient.
satisfactory. That is why it depends upon case to case. The concerned investigating officer might say that according to him, it is the person by birth is innocent.
Yes,
But from the entire report, that is his opinion. That is not report. His
Hmm.
report is entire all the documents what is
yes,
there.
yes,
So the referral authority have to come to the conclusion. And what would be the conclusion on the basis of all the materials in that investigating report
collected during the
by
period.
the concerned investigator. Here is a, we do not know the case. what
But
are the
here,
materials-
here,
What are the materials available in the case of Sushil Mandal? We do not know. But the Muslim Mandal's case, the full bench, honorable full bench have clarified. Following the decision of Muslim Mandal.
but
is
here
why
in
we-
this judgment
we have
also,
asked
my lord,
to-
this policeman has been referred.
No, we are not going beyond Muslim Mandal.
Yes,
And a division bench will not able to go above it.
definitely, my lord.
Right?
But
Here is a case.
here, my lord, the superintendent of police also agreed by the
Listen,
inquiry officers.
that's why you have
Use
asked you
Mandal.
how you have obtained a certified copy. The record reveals different way. In December 2017, the police officer in charge of border branch issued him a notice under the Foreigners Act to show that he is an Indian, not a foreigner. He failed to place any other. He was a vegetable vendor in Guwahati city. So he failed to place any document. During that process, the concerned officer wrote to the Superintendent of Police Board of Kamrup, that is the authority, the referral authority. The referral authority then allowed him to make a complete investigation of it. Then he made the investigation. He notes down initially the name of the proceedee, his father, his present address, as well as the address of it. During that inquiry, he said, the proceedee said that he is presently staying in somewhere in the Potasil area. And he is from district Korpeta under Koyakota. After the power given to him to make the investigation, when he went there, found the proceedee, because proceedee was given 15 days time to submit all the documents. He did not. He found that proceedee left that. Again, after some time to inquire, he did not find the procedure. All along, he collected the report. Everybody said he left. People, whoever is there, they're saying the landlord and everything else. He happens to be from Borpeta, as you was saying. Nobody was sure about his rest. So, the investigating officer sent message, WT message to the concerned police station at Koyakuchi to make an inquiry into submit. The reply comes from the Koyakuchi police station saying that during the inquiry, it is found that he is citizen of India by birth, which you have. There is no NEFT case pending against him. Though he has produced documents regarding his nationality, again he is asked to appear before Potasilambari police station branch with the papers. This is the WT message from the parent. The proceeding did not appear before the Potasil police station along with the documents. After going through everything, the concerned investigating officer gives his opinion that during the course of inquiry, prima facie manner, it directs to me that it is something he has written, not possible. The suspect of the case, such and such, had already left his present address at Guwahati permanently for his native village and district Borpeta, he has said. Reply received from Koyakuchi outpost that the suspect is an Indian by birth. Hence, the case may be dropped. Forwarded to the Honorable Foreigners Tribunal Court, Kamrup, Metro Guwahati for kind opinion. Right?
Yes.
Now he said, yes, it should be referred to the Foreigners Tribunal. Thereafter, going through these reports, the referral authority, that is the Deputy Commissioner of Police, Border, Guwahati, he writes, before that, of course, the Inspector of Border,
Yes.
he makes a report. Peruse and supervise the case records and verification of the document. Agree to the opinion of the inquiry officer's report. Hence, the case is forwarded to the Honorable Member, Foreigners Tribunal, Kamrup Metro, for opinion.
Yes.
And the referral authority forwarded to the Foreigners Tribunal, Kamrup Metro. Opinion. Now, what was not before the investigating officers were the relevant documents. Right? So the Koyakuchi outpost asked the proceeding to appear before the investigating officer or the inquiry officer along with the document, he did not appear. As because the Koyakuchi outpost have written that the proceeding is an Indian citizen by birth. And that's the reason when these documents are not before this particular investigating officer or the inquiry officer, he has found that for the opinion it is better to send it to the Foreigners Tribunal. Now tell us in these circumstances.
But
whether-
my lord, in some cases we have found police without asking any documents simply taken the name and address of the proceedee,
That's why we say
and thereafter not a single
What we are
communication
saying
has been
that
made
will-
from the police, but subsequently they have
you
given
have seen
report that
Muslim Mandal. You have seen Muslim Mandal.
yes,
What is it? On verification of the
yes,
entire report.
Yes.
It is the referral authority has to decide. And this is the record.
Yes.
No documents was placed by the proceeding. Proceeding was asked to place the document, but he did not place. Even the Koyakuchi outpost have asked the proceeding to submit the document. He did not.
That is, my lord, I have submitted that we have found in several cases,
Okay,
my lord.
come back, that every case will differ, right? You
Yes,
cannot equate all the cases together.
yes,
And the judgments are here only for the purpose of the proper adjudication of the case.
yes.
That particular facts of the case may not be applicable to A case, B case, C.
Yes, my lord, but the proposition, if the proposition is
Definitely.
same, my lord, that
Definitely.
can be taken into account, my lord.
Sorry, either party, my lord, budget run by the authority itself because they are losing money and also, my lord, you will be hurt by June. So that's why I paid it, getting on system, he get 4.
Fourth of April will be,
It is for the
The
petition.
joint prayer of the parties.
Yep.
We made it joint prayer of the party.
Right.
Nothing. Listen.
fourth of April.
4th of April.
Perhaps that will also come before the present division bench cannot take up this matter. That is also another.
Likely to be changed.
The order of status quo may continue.
Is it required? I don't think.
Probably the observation was till next date. That's why I'm saying.
The government says that my lord, these matters become infrastructure. I'll apprise the court on the become infrastructure.
But otherwise also, since the question is important, my lord, that's why it requires a determination.
Interim. Same one. 41, 42.
41,
common order
42,
क्या हुआ?
same.
I am representing in 41, I see.
41 and 42 both are by and between the same party.
Interim order.
My lord, before that, my lord, I like to rely upon another judgment, my lord.
Your fourth one.
Yes, my lord. This one in WPC number 7104 oblique 2015. Seven 2015, Alani Bibi versus Union of India. Here the proposition is that, my lord, the tribunal have to confine to the terms of the reference made by the referral authority, my lord, not travel beyond that.
Fine.
Santosh Das and this Alani Bibi is almost the same, my lord.
But can you explain one thing? When the tribunal, when the referral authority refers the matter to the tribunal, that the Foreigners Act 1946, saying that the proceeding is found to be a suspected foreigner. The reference is or is not a foreigner, as per the act, the rules or the orders. Now, notice is also given. Notice is also given under the Foreigners Act. Only during the process, on the basis of the evidence adduced by the proceeding, the tribunal will come to a finding, first of all, that the proceeding is not a foreigner. If it is a case that the prosody is a foreign.
Hmm.
Then they come this on the stream, whether the prosody
66.
could establish that he is a foreigner or
In
he is a
between.
foreigner of come after 25th of or
Or-
on or
or-
after 25th
yes.
of 1971 March
Or
prior to.
prior.
Now, in the notice, in some of the cases, it is true. That in some of the cases, as we have discussed in the first half,
Yes.
the investigating officer writes it seems to be a foreigner.
Yes.
But the decision whether he's a foreigner of this stream or that stream, the police officer cannot decide. Police officer, anywhere, if it is suspected to be a foreigner, as per the Foreigner Act doesn't say which stream. Right?
Yes.
Police have to say, yes, suspected to be a foreigner. And on that basis, the reference should be there by the referral authority. Accordingly, under the Foreigners Act, the procedure notice will go. Only during the process of the trial before the tribunal, it can be determined either he is a foreigner, is not a foreigner, and if it is a foreigner of which stream. Whether prior to that, is it possible for any authority to say that no, he's a foreigner of this stream, but he's not a foreigner of that.
My lord, in
See,
that
process of notice, what has happened, since all this in the state of Assam, it has followed from the IMDT Act. And the tribunals in each district, they have their own procedure. That is why Muslim Mandal have clarified. But is it possible for the IO to give a report that he is a foreigner, not a foreigner, if it is a foreigner of district, unless all suspects, either is a foreigner, if he is suspected he is a foreigner of that stream, that is fine, because of the documents placed before the IO. Then also the reference is again that he is a foreigner or not a foreigner. In many cases, we have seen that some of the procedure could place the certificates issued by some of the authorities. They have entered into Assam sometimes in 1960 or 1947, 1948. Showing that document, the report is that the police officer will say, investigating officer, since has this document, he appears to be the stream of
66 to 71.
But during the procedure, he has found that the prosecutor failed to establish his case or her case linked to that particular man who has such migration certificate. Necessarily, the stream was at that point of time, as per the IO, it's very clear that he, according to this document, he appears to be of the foreigner of 1966 to 1971 stream. But during the procedure, during the trial before the tribunal, it is possible that a prosecutor cannot prove his or her linkage with that particular man who has this migration certificate.
Yes.
Automatically, will come a person from a stream of 1971. Then what will happen? The reference is bad. You
Right.
want to mean, how can you say the reference is bad?
But my lord, in that
That is the, see, basically you will have to stick to the act. Act is very clear. He is or is not a foreigner. Not beyond that. There cannot be 2-3 streams. Only during the tribunal, while the process was taken up, then only it can be determined. Otherwise, it is not possible. We have seen many such cases where on the basis of this migration certificate, police officer is to write that he belongs to this stream. May not be possible because the prosecutor may not
Yes.
prove.
the
At
lordship
that
was
point of time, the prosecutor cannot say, no, I was particularly, the reference was only for this, not for the 71 stream. Then what will happen?
your lordship is correct, but after going through the judgments,
is
my
the
lord,
reason
my
you see
understanding
That you see, there are 92, 94, 96, 97, 98,
98.
99 Muslim Mandal.
Yes.
They have described everything.
Yes.
Right. Now, the Muslim Mandal's case, the full bench did not say that you have to specify which period.
Did not say.
Did not state. Knowing
But
fully
one
well-
thing said that the referral authority should concise to at the time of reference of the
Exactly. That is the reason. It is not possible. A police person cannot say that he is a stream of this particular 1960 to 71 or 71 or after 71. That can be ascertained only by the tribunal.
My lord, in that case, my lord, after
That
go,
is why the Muslim Mandal have never said, if you read the Muslim Mandal case, then the full bench have considered all those aspects,
yes,
right? So Muslim Mandal hasn't changed that stream, did not specify the stream.
system is nothing there, not there. My lord, as per my understanding, after I go through the judgments, my lord, the tribunal has given the option.
No, that
After
is,
the reference, if tribunal found that the materials which has produced at the time of reference is not is contrary with the reference made by opinion given by the inquiry officer. In that case, my lord, the tribunal has remanded back the matter to the referral authority with a note, a specific note, that so and so, so and so, so and so is contrary. So fresh reference may
Okay.
be made, my
we'll
lord.
deal with, definitely we'll deal with this.
In that case, my lord, the
Yes.
option is there. So my humble submission before your lordship, the judgment which is placed before your lordship is squarely cover my case.
Okay.
So I pray
We'll
before
consider,
your,
definitely will consider.
yes,
You, the mark portions you are showing about, right?
yes, my lord.
Only the start mark paragraph or other
Yes.
paragraph?
That's paragraph, my lord.
Okay, we'll take care.
Yes.
You are saying this is also similar to that of Santosh Das, right?
Yes, my lord. Santosh Das.
This is the Falini Bibi.
Yes, Falani Bibi. Falani Bibi.
Hmm.
And,
I think in Mr. Sharma, subsequently in the form of the judgment, yes, coordinate bench have also considered Santosh Das, right?
Yes, yes.
Can you give us Santosh Das judgment?
Santosh Das judgment is there, my lord.
Just give the citation.
2017, 2 GLT,
Oh, it is already there. Okay. Okay.
Santosh Das, para 14, 15 and 16, my lord.
Santosh Das, then which one is para 5789?
My lord. 5789 is Sushil Mandal. 2022 1 GLT 790. 57810.
And Santosh Das,
Santosh Das, Mandal 2017 2 GLT.
which is the 1065, right?
Yes, 1065, 14, 15 and 16, my lord, para. And another one, my lord, this citation is the 2017 5 GLT 831. Para 17, 18, 19 and
5
20.
GLT
831.
para
17, 18, 19 and 20. Poranuddin alias Poran Ali versus Union of India.
Okay. We'll look.
And the first one is Ballad Monwara Khatun
On that you
WBC
have given WBC 2674.
2674 and 2022 1 GLT 790.
Okay. Yes, Mr. Sharma.
Yes, Lordship, these issues have again reconsidered by this coordinate bench, Lordship. In the case of 2370 2023, Aziz Mia, alias Muhammad Aziz Mia, WB
2370 2016.
2023, Lordship. At first, I am reading, Lordship, para 3, 4, and 5, Lordship.
Just a minute, let us put together.
Okay.
Yes.
At first, I am reading para 3, 4, and 5, Lordship.
Hmm.
In the proceeding before the tribunal, the petitioner made an application with a prayer that the proceedings itself be dropped, inasmuch as the inquiring authority in its report submitted that during the inquiry, the petitioner could produce a voter list of 1966, which belonged to his father, to prove that he is not a foreigner, and accordingly, the inquiring authority had given a view that the petitioner is not an illegal migrant, but in spite of such report by the inquiring authority, the superintendent of police border Kamrup made a reference to the foreigners tribunal, resulting in registration of the aforesaid application number 165 of 2015. By the order dated 23/2023, the tribunal was of the view that as the referral authority had suspected the petitioner to be an illegal migrant of post 71, the prayer to drop the proceeding against the petitioner cannot be accepted. Being aggrieved, this petition is instituted. Mr. R. Ali, learned counsel for the petitioner, submits that under the paragraph number 97 of the judgment of the full bench of this court in the state of Assam and others versus Muslim Mandal and others reported in 2013-1 GLT 809, there is a requirement under the law that before making a reference, an inquiry should also be conducted by the authorities, giving an opportunity to the suspected person to prove before the authority itself that he is not a foreigner. By taking recourse to paragraph 97 of Muslim Mandal Supra, it is the submission of Mr. R. Ali, learned counsel for the petitioner, that as in the instant case, the petitioner succeeded in proving before the inquiring authority that he is not a foreigner, and therefore the subsequent reference by the superintendent of police border to the foreigners tribunal is a defective reference, and further, as the reference itself is defective, no jurisdiction is vested upon the tribunal to proceed against the petitioner. Accordingly, it is the submission that the conclusion arrived at by the tribunal in order to impugn order dated 23/2023 is unsustainable in law. Then paragraph 5, to substantiate his submission, the petitioner has relies upon earlier judgment rendered by the division bench in WPC number 2674 of 2016 in Munwara Khatun versus Union of India and others. By referring to the said judgment of the division bench, it is the submission of Mr. R. Ali, learned counsel for the petitioner, that as the reference made by the superintendent of police border Kamrup was defective, therefore there is a requirement under the law to return the reference back to the superintendent of police border Kamrup, and in these circumstances, the reference before the tribunal would not be maintainable any further. Then, Lordship, I will come to paragraph 11, Lordship. Same issue has been raised in this case, Lordship. The concept of returning back the reference is being, paragraph 11 from para 11 I am reading, Lordship.
It starts at,
The concept of
there are two para 11. The second para 11.
second para 11, Lordship.
Yes.
Yes. The concept of returning back the reference is being submitted by placing a reliance on the judgment of division bench rendered in Munwara Khatun Supra. The relevant paragraph in Munwara Khatun Supra had been provided as abstracted. In the light of above position, we feel that tribunal ought to have returned the reference back to the referral authority, that is this SP border Dhubri. Notice issued by the tribunal was apparently contrary to the reference made. Though this court has clarified that if tribunal finds a reference to be contrary to the materials on record, or finds the reference to be faulty, it should remand the matter back to the referral authority for making a fresh reference. But in the instant case, we find from the affidavit of the Director General of Police, Assam, dated 18/6/2016, that report of the inquiry officer as well as endorsement of SP border Dhubri were made after proper application of mind. In such circumstances, without entering into merits, we feel that impugn order passed by the tribunal dated 14/3/2016 cannot be sustained and is accordingly set aside. writ petition is disposed of. Then Lordship, para 12. In the matter of Monora Khatun, Supra, the factual situation was that the Superintendent of Police Border, after proper application of mind on the report of the inquiring authority, came to a conclusion that the suspected person therein did not appear to be a foreigner. In other words, it was Superintendent of Police Border who had arrived at such a conclusion, and no finality was given to any report of an inquiring authority. In the instant case, it is noticed that although the report of the inquiring authority may be that the petitioner is not a foreigner, but SP Border, upon going through the materials on record, did not arrive at any conclusion that petitioner is not a foreigner, which again also impliedly flows from his conduct that he had made a reference to the tribunal for rendering an opinion on the said question. On the facts of the present case, we have noticed that inquiring authority in its report dated 28/3/2001 had stated that during the inquiry, the petitioner had produced the voter list of 1966, which belonged to his father, and therefore the petitioner is not a foreigner. Para 14, Lordship, we are constrained to observe that a mere claim by the suspected person by referring to a voter's list, claiming a person therein to be his father, is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter's list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with the further materials acceptable in law. Accordingly, the report of the inquiring authority on its own cannot be viewed to be conclusive in nature that the petitioner is not a foreigner. From such point of view, we do not notice any infirmity in the reference made by the SP Border to the Foreigners Tribunal for rendering an opinion as to whether petitioner is a foreigner who entered the state of Assam from the specified territory. This is the case, Lordship. So, Lordship, here inquiry officer's report has not attained finality in this case, Lordship, as per this order. Again, Lordship, in the case of Rukia Begum Borbia, Lordship, WPC 2279 of 2021. WPC 2279 of 2021. Two seven nine. Itu nanti tunggu. At first, I am reading para 2 and 3, Lordship. The petitioner Rukia Begum Borvia was referred to the Foreigners Tribunal for Kasar Silsar, resulting in the registration of F4D 415/2015. The tribunal passed an order dated 25/1/2019, which is extracted as below. OP is absent without any step. SP Border Kasar referred for opinion whether OP is Indian or foreigner. In the reference, LPU stated that OP produced valid document for which he has to be beyond doubt. The reference itself, and as per verdict of the Guwahati High Court in WPC 7104, stated that if the tribunal prima facie arrives at a satisfaction that reference made to it is faulty and contrary to the materials on record, the tribunal should send back the reference to the referral authority with a disagreement note pointing out that the error or fault in the reference. Once reference is returned back to the referral authority, it would be the duty of the referral authority to make a fresh reference to the tribunal after removing the defect or fault as pointed out by the tribunal. Hence, this reference is returned back to the SP Border Kasar to make a fresh reference after removing the defect or fault. With this observation, instant case is disposed of. A reading of Para 3, a reading of the order dated 25/1/2019 goes to show that tribunal, by following the judgment of this court rendered in Phalani Bibi versus Union of India and 6 others dated 18/8/2017, passed in WPC number 7104 of 2015, have arrived at its conclusion that the reference itself is faulty and contrary to the materials on record, and therefore it be sent back to the referral authority with a disagreement note pointing out the error or fault in the reference. Although the law as understood by tribunal as laid down in Phalani Bibi Supra had been quoted and also stated that if the reference is erroneous or faulty, it has to be returned back to the referral authority with a disagreement note pointing out the error or fault, but the order dated 25/1/2019 does not discern any disagreement note being put up by the tribunal pointing out as to what was the fault or defect. We have to understand that the laws that may be laid down in any judgments are to be followed only by following the purports of the judgment itself, and not merely quote a judgment and in the guise of following the judgment do an act as may be enabled in such judgment. A reading of the order dated 25/1/2019 does not reveal that the tribunal had done the needful of putting up a disagreement note pointing out the error or fault in the reference, and merely because Phalani Bibi Supra, a provision has been made for returning back a judgment to the referral authority. In the instant case also, the tribunal deemed it appropriate to refer it back to the referring authority. Then, Lordship, I will come to Para 30, Lordship. 13. In view of the provisions of Section 6A of the Citizenship Act 1955, Clause 2(1) of the Foreigners Tribunal Order 1964, would now have to be understood that once a reference is made, the reference would be whether the person concerned is or is not a foreigner, meaning thereby whether the person concerned is a foreigner who had entered the state of Assam from the specified territory on or after 25/3/1971, or he is a person who belongs to any of the other categories, that is, a person who entered the state of Assam from the specified territory before 1/1/1966 or between 1/1/1966 and 25/3/1971. No other meaning can be attributed to the reference under Clause 2(1) of the Foreigners Tribunal Order 1964, that is, whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946. We further take note that even if a reference is made by setting up a question whether the person had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, the reference would have to be understood to be a reference under clause 2(1) of the Foreigners Tribunal Order 1964, that is, as to whether he is a foreigner or not. If the reference is worded whether the person concerned is a person who had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971 in order to arrive at any such conclusion that the reference itself is faulty inasmuch as the decision of the tribunal upon the materials on record would be that the person concerned had entered the state of Assam from the specified territory on or after 25/3/1971. In such circumstance, the only situation that can be envisaged is that the tribunal first arrives at a conclusion of its own that the person concerned had entered the state of Assam from the specified territory on or after 1971, meaning thereby that the reference itself had been answered by the tribunal. After having answered the reference, it would be an inconceivable situation that merely because the reference is worded whether the person had entered the state of Assam from the specified territory between 1/1/1966 to 25/3/1971, it has to be referred back to the referral authority to make a fair reference now, putting up a question whether the person concerned had entered the state of Assam on or after 25/3/1971. In such situation, as the matter would have to be referred back only after a final decision has been arrived at, and now if the reference is again made with a corrected expression in the questions framed, the same may lead to further complications that the subsequent reference would be barred by the principle of res judicata inasmuch as it would be a subsequent reference on the same issue between the same set of parties where an earlier decision had already been arrived at. It is noticed that in Phalani Bibi Supra, the aforesaid aspect of the further implication of a corrected reference being again made had not been gone into, and from such point of view, it can be said that the view taken therein would be per inquirium of the further consequences of fresh reference being made. In para 14, Lordship, Mr. D. Majumdar, learned additional AG, Assam has also placed reliance upon the provisions of Supreme Court rendered in paragraph 13 of the judgment in the state of UP versus Ajay Kumar Sharma reported in 2016-15 SCC 289, which is extracted as below. Time and again, this court has emphatically restated the essentials and principles of precedent and of this stare decisis, which are the cardinal feature of the hierarchical character of all common law judicial systems. The doctrine of precedent mandates that an exposition of law must be followed and applied even by coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts. That is to say that a smaller and later bench has no freedom other than to apply the law laid down by the earlier and larger bench. That is the law which is said to hold the field. Apart from Article 141, it is a policy of the courts to stand by the precedent and not to disturb a settled point. The purpose of precedents is to bestow predictability on judicial decisions, and it is beyond cavil that certainty in law is an essential ingredient of rule of law. A departure may only be made when a coordinate or co-equal bench finds the previous decisions to be doubtful, logic, or efficacy, and consequently its judicial conscience is so perturbed and erode that it finds it impossible to follow the existing ratio. The bench must then comply with the discipline of requesting the Honorable Chief Justice to constitute a larger bench. A reading of the provisions in paragraph 13 of the provisions of the Supreme Court in Ajay Kumar Supra makes it discernible that Supreme Court had emphatically restated the essentials and principles of precedent and of stare decisis, which are a cardinal feature of the hierarchical character of all common law judicial systems. The term stare decisis is defined in the Black's Law Dictionary to mean the doctrine of precedent under which a court must follow earlier judicial decisions when the same point arises again in a litigation. We are in complete agreement with the principle of precedent and stare decisis that the court must follow the earlier judicial decisions when the same point arises in a litigation, but at the same time, it is also an accepted principle of law that doctrine of par inquirum is an exception to the doctrine of stare decisis. The doctrine of par inquirum is defined to be a judicial decision which was wrongly decided because the judge or the judges were ill-informed about the applicability of the law. In the instant case when the decision in Phalani Bibi Supra was rendered, the further technical complication that may arise upon a fresh and corrected reference being made that it may be barred by principle of res judicata was neither urged upon nor was gone into by the court. The question whether the reference is faulty or not can only be determined after there is a decision being rendered that the person concerned entered the state of Assam from the specified territory on or after 25/3/1971, whereas the referred question was whether he entered the state of Assam between 1/1/1966 and 25/3/1971. In other words, the conclusion as to whether the reference is faulty or not can be arrived at only after a final decision has been rendered on the materials being produced, and therefore, as a decision had been rendered upon the materials being produced, the same issue, if again referred back with any correction in wordings in the reference, may invoke the principles of res judicata that it cannot be referred and answered again, as it would be a subsequent reference on the same issue which is between the same parties and was decided in a prior proceeding. In these circumstances, we are of the view that the principle of par inquirum would be applicable in the instant case rather than a principle of stare decisis. In view of above, as the principle of par inquirum is more applicable rather than it being the principle of stare decisis, the principle laid down in the paragraph 13 of Ajay Sharma Supra can also be answered accordingly, that the earlier decision in Phalani Bibi needs a further clarification to the extent that if the conclusion as regards the faulty reference can be arrived at only upon a final decision, it would be in the interest of all the parties to have the final decision being controverted to an opinion rather than to undergo the technicality of returning the reference, having it corrected and decided once again. From such point of view, we are unable to agree with the order dated 25/1/2019 of the tribunal. In view of such answer, we are of the view that subsequent order dated would have to be considered from the another perspective, although technically the corrected reference would not be maintainable, but however, even if the earlier decision arrived at that the petitioner is a person who had entered the state of Assam from the specified territory on or after 25/3/1970 was is itself a final decision, but the petitioner also deserves an opportunity to assail the said final decision on its own merit. This so Lordship, here in this case, question of return back the reference to the referral authority does not arise after and Lordship, if we consider the materials what placed before your lordship in this writ petition, lordship, that documents also have so many discrepancies, lordship. May submit, lordship. Here, lordship,
Tell us the relevant page.
lordship, page 44. Order, lordship, from top. Here, lordship, reference was made against one Ruksan Ali, son of Muhammad Saijuddin, a resident of Govindanagar, Lalganesh, PS, Potasil, Ambari, district Kamrup Metro, Assam. And lordship, present proceeding claims that he is the resident of Borpeta, lordship, and this Ruksan Ali and Ruksan Ali of Borpeta district are same and one person, lordship. Lordship, your lordship procedure relies on a voter list of 1965, lordship, at page 22. Page 22. Village Sakirvita, Moja Betabari, subdivision Borpeta, Assam. Here, one Afazuddin names is appearing, lordship. Afazuddin, son of Kuku Ali. Then, lordship, next voter list is same, lordship, Afazuddin Sehra Khatun, Afazuddin son of Kuku Ali.
Elder brother of the petitioner's father. So I have stated in my.
Then, lordship, petitioner relies on the voter list of 1997 at page 26. Here, her father's name first time reflected at the age of 48 years, lordship. Saijuddin Mia.
It's not 77, 97.
97, I'm telling 97, lordship. At the age of 48 years, lordship. His name first time reflected, and as per 1966 voter list, his father's name should be Kuku Ali, but here Saijuddin Mia, son of Kaed.
Father, grandfather. That is Kupal is a grandfather. Overall, not father.
Gompe.
I have stated in my.
Saijuddin Mia in respect of Saijuddin Midda Kaed Ali. And here also in this voter list, proceedings name first time reflected in proper age, lordship, age 18. Ruksan Ali, son of Saijuddin. But this Saijuddin Mia cannot able to establish his link with the person whose name existed in the voter list of 1966, in 1965 at village Sakirvita. That is Kuku Ali. So, lordship, here in this case, petitioner could not able to prove the citizenship of his father itself, lordship. Then Lordship, procedure relies on some land document. Right? Okay. Nineteen 59 land document, Lordship. So here one titleist name appear, Lordship, page 19. Perhaps he is the projected father of the proceeding. Here, Lordship, Syed Ali, son of Dullah. Not neither Quet nor Kuku Ali, Lordship.
Which page?
Page 19. Hmm? Syed Ali নহয় নেকি? Then and petitioner claimed that Syruddin is his father, Lordship, where in respect of Syed Ali, his father's name was written as Kubayr, nor Kuku Ali, nor Kayed Ali, Lordship. So these documents are pick up documents, Lordship, from somewhere. Proceed pick up this document and trying to
See, come to page number 20.
Lordship.
Here you will see doc number 209.
209, yes, Lordship.
There, name of one Syed Ali, then Kubali is there.
Yes, Lordship.
Syed Ali, Kubali,
Kubat Ali, Kubot Ali.
then Hafizuddin and Syruddin.
Yes, Lordship.
Now Syed Ali, then Kubali's father is Dullah,
Dullah.
and Hafizuddin and Syruddin's father is Kubali.
Kubat Ali.
Yes.
Hmm.
Yes.
So you can either it is Kubali or Kubtali, whatever.
Yes, Lordship. Neither it is
Then doc number 208. Hafizuddin, Syruddin, Pita,
Kubat Ali.
Kubat
Kubali.
Kubat Ali.
Kubat Ali.
Kubat Ali, it is Kubot Ali.
Kubat Ali is
Kubat Ali,
written as
that
Kubat
is
Ali.
Kubot Ali. Then again, doc number 202.
Hafizuddin, Syruddin, Kubat Ali.
Hafizuddin and Syruddin,
Kubat Ali.
Kubot Ali.
Kubat Ali.
Now, the one more you just see. Page number 21. উত্তৰাধিকাৰী সূত্ৰে 2 নম্বৰৰ স্থলত হাফেজউদ্দিন, Syruddin, Pita, Kubat Ali হ'ল. So, doc number 209. Kubat Ali was substituted by Hafizuddin and Syruddin.
Yes.
Then the second column.
Bahutra.
Apahutre means
Bahutra মানে কি? Bahutra. আবাহিক বা হিন্দা হচ্ছে
I don't know this term.
Yes.
But that is not Kuko Ali.
Yes.
It is Kubat Ali, has nothing
Kubat
to
Ali.
do.
Well, I have
And
stated.
moreover, how this Syed Ali or and Kurt Ali, whose father is Tula,
Yes.
whether they are by right of inheritance or by purchasing right, they have entered into that line, it is not there.
Right of inheritance.
Anyway, what else?
I have stated at para 2, my lord, the actual name. Kubaid Ali is the grandfather. And the father's name. Nafazuddin is the brother of the fathers of the procedure.
So Lordship, once it is referred, Lordship, petitioner has to prove his case before the tribunal that he is an Indian citizen. Lordship.
What else?
My lord, in the judgment which my learned friend relied in WPC 2370/2023, paragraph 12, my lord, there is some differences in between the present case and the case cited by my learned friend.
Sure, we'll look into it.
Para 12, my lord,
You have noted down
para 12,
of that judgment, right?
yes,
Aziz Mia,
yes.
you have noted down.
There is some difference because the superintendent of police in arrived at the such conclusion in this case, but in that case the superintendent of police was not arrived in that conclusion. That is the difference. That's why, my lord, that judgment I think will not be.
Mr. Sharma, anything you like to add?
Lordship.
Anything you like to add? First,
Yes. Lordship, my humble submission is that police report cannot be conclusive one, Lordship.
that is a different issue.
Yes, Lordship.
See, basically it is the, as per the full bench referral. authority.
Yes, yes,
Police officer is not.
yes,
the
yes,
referral.
Lord.
Anything you want to say?
That's all, Lord.
Mr. Islam, anything else?
My lord, my humble submission before your lordship, since the judgment which I have cited before your lordship,
Definitely.
that may be taken into consider. And another prayer before your lordship, that if the one opportunity may be given to the petitioner, the remanded back the matter to the tribunal for the fresh trial, my lord. That is my humble prayer before your lordship. Because in that case, my lord, due to some misguidance, my lord, the petitioner could not appear before the tribunal. So it's the best option if the one opportunity has to be given to the petitioner before the tribunal to place his documents and prove himself as a citizen of India. That's my humble prayer.
What Mr. Rafiqul Islam considering for the petition. So who's there for election? H. Kuli.
Pegu.
Keep it. I always.
GPEG and TPEG, my lord.
Planet Council on behalf of Mr. AIL is pending council. Check. Also heard Mr. Gunjan Sharma, pending council from Department of Assam for test 3, 5 and 6. As well as Mr. R. Talukder, Government Advocate Assam for test 7. Arguments